Hello, everyone. Today's case is Wal-Mart Stores Incorporated versus Dukes. This is a case about gender discrimination and how the class action was certified. So let's get into it. Respondents, current and former employees of petitioner Walmart, sought judgment against the company for injunctive and declaratory relief, punitive damages, and back pay on behalf of themselves and a nationwide class of some 1.5 million female employees because of Walmart's alleged discrimination against women in violation of Title VII of the Civil Rights Act of 1964. They claim that local managers exercise their discretion over pay and promotions disproportionately in favor of men, which has an unlawful disparate impact on female employees, and that Walmart's refusal to cabin its manager's authority amounts to disparate treatment. The district court certified the class, finding that respondents satisfied Federal Rule of Civil Procedure 23A and Rule 23B2's requirement of showing that the party opposing the class has acted or refused to act on grounds that apply generally to the class, so that final injunctive relief or corresponding declaratory relief is appropriate respecting the class as a whole. The Ninth Circuit substantially affirmed, concluding inter alia, that respondents met Rule 23A2's commonality requirement, and that their back pay claims could be certified as part of a B2 class because those claims did not predominate over the declaratory and injunctive relief requests. It also ruled that the class action could be manageably tried without depriving Walmart of its right to present its statutory defenses if the district court selected a random set of claims for evaluation and then extrapolated the validity and value of the untested claims from the sample set. Held. The certification of the plaintiff class was not consistent with Rule 23A. Rule 23A2 requires a party seeking class certification to prove that the class has common questions of law or fact. Their claims must depend upon a common contention of such a nature that it is capable of class-wide resolution, which means that determination of its truth or falsity will resolve an issue that is central to the validity of each one of the claims in one stroke. Here, proof of commonality necessarily overlaps with respondents' merits contention that Walmart engages in a pattern or practice of discrimination. The crux of a Title VII inquiry is the reason for a particular employment decision, citing Cooper v. Federal Reserve Bank of Richmond, and respondents wish to sue for millions of employment decisions at once. Without some glue holding together the alleged reasons for those decisions, it will be impossible to say that examination of all the class members' claims will produce a common answer to the crucial discrimination question. General Phone Company of Southwest v. Falcon describes the proper approach to commonality. On the facts of this case, the conceptual gap between an individual's discrimination claim and the existence of a class of persons who have suffered the same injury must be bridged by significant proof that an employer operated under a general policy of discrimination. Such proof is absent here. Walmart's announced policy forbids sex discrimination, and the company has penalties for denials of equal opportunity. Respondents' only evidence of a general discrimination policy was a sociologist's analysis asserting that Walmart's corporate culture made it vulnerable to gender bias. But because he could not estimate what percent of Walmart employment decisions might be determined by stereotypical thinking, his testimony was worlds away from significant proof that Walmart operated under a general policy of discrimination. The only corporate policy that the plaintiff's evidence convincingly establishes is Walmart's policy of giving local supervisors discretion over employment matters. While such a policy could be the basis of a Title VII disparate impact claim, recognizing that a claim can exist does not mean that every employee in a company with that policy has a common claim. In a company of Walmart's size and geographical scope, it is unlikely that all managers would exercise their discretion in a common way without some common direction. Respondents' attempt to show such direction by means of statistical and anecdotal evidence falls well short. Respondents' back pay claims were improperly certified under Rule 23b2. Claims for monetary relief may not be certified under Rule 23b2, at least where the monetary relief is not incidental to the requested injunctive or declaratory relief. It is unnecessary to decide whether monetary claims can ever be certified under the rule because, at a minimum, claims for individualized relief like back pay are excluded. Rule 23b2 applies only when a single indivisible remedy would provide relief to each class member. The rule's history and structure indicate that individualized monetary claims belong instead in Rule 23b3, with its procedural protections of predominance, superiority, mandatory notice, and the right to opt out. Respondents nonetheless argue that their back pay claims were appropriately certified under Rule 23b2 because those claims do not predominate over their injunctive and declaratory relief requests. That interpretation has no basis in the rule's text and does obvious violence to the rule's structural features. The mere predominance of a proper B2 injunctive claim does nothing to justify eliminating Rule 23b3's procedural protections and creates incentives for class representatives to place at risk potentially valid monetary relief claims. Moreover, a district court would have to reevaluate the roster of class members continuously to excise those who leave their employment and become ineligible for class-wide injunctive or declaratory relief. By contrast, in a properly certified B3 class action for back pay, it would be irrelevant whether the plaintiffs are still employed at Wal-Mart. It follows that back pay claims should not be certified under Rule 23b2. It is unnecessary to decide whether there are any forms of incidental monetary relief that are consistent with the above interpretation of Rule 23b2 and the Due Process Clause because respondents' back pay claims are not incidental to their requested injunction. Wal-Mart is entitled to individualized determinations of each employee's eligibility for back pay. Once a plaintiff establishes a pattern or practice of discrimination, a district court must usually conduct additional proceedings to determine the scope of individual relief. The company can then raise individual affirmative defenses and demonstrate that its action was lawful. The Ninth Circuit erred in trying to replace such proceedings with trial by formula, because Rule 23 cannot be interpreted to abridge, enlarge, or modify any substantive right. A class cannot be certified on the premise that Wal-Mart will not be entitled to litigate its statutory defenses to individual claims. Reversed. Scalia delivered the opinion of the court, parts 1 and 3 of which were unanimous, and part 2 of which was joined by Chief Justice Roberts, Kennedy, Thomas, and Alito. Ginsburg filed an opinion concurring in part and dissenting in part, in which Breyer, Sotomayor, and Kagan joined. Justice Scalia delivered the opinion of the court. We are presented with one of the most expansive class actions ever. The District Court and the Court of Appeals approved the certification of a class comprising about 1.5 million plaintiffs, current and former female employees of petitioner Wal-Mart, who allege that the discretion exercised by their local supervisors over pay and promotion matters violates Title VII by discriminating against women. In addition to injunctive and declaratory relief, the plaintiffs seek an award of back pay. We consider whether the certification of the plaintiff class was consistent with Federal Rules of Civil Procedure 23A and B2. Petitioner Wal-Mart is the nation's largest private employer. It operates 4 types of retail stores throughout the country: discount stores, supercenters, neighborhood markets, and Sam's Clubs. Those stores are divided into 7 nationwide divisions, which in turn comprise 41 regions of 80 to 85 stores apiece. Each store has between 40 and 53 separate departments and 80 to 500 staff positions. In all, Wal-Mart operates approximately 3,400 stores and employs more than 1 million people. Pay and promotion decisions at Wal-Mart are generally committed to local managers' broad discretion, which is exercised in a largely subjective manner. The local store managers may increase the wages of hourly employees within limits with only limited corporate oversight. As for salaried employees, such as store managers and their deputies, higher corporate authorities have discretion to set their pay within pre-established ranges. Promotions work in a similar fashion. Walmart permits store managers to apply their own subjective criteria when selecting candidates as support managers, which is the first step on the path to management. Admission to Walmart's management training program, however, does require that a candidate meet certain objective criteria, including an above-average performance rating, at least 1 year's tenure in the applicant's current position, and a willingness to relocate. But except for those requirements, regional and district managers have discretion to use their own judgment when selecting candidates for management training. Promotion to higher office, such as assistant manager, co-manager, or store manager, is similarly at the discretion of the employee's superiors after prescribed objective factors are satisfied. The named plaintiffs in this lawsuit, representing the 1.5 million members of the certified class, are 3 current or former Walmart employees who allege that the company discriminated against them on the basis of their sex by denying them equal pay or promotions in violation of Title VII of the Civil Rights Act of 1964. Betty Dukes began working at a Pittsburgh, California Walmart in 1994. She started as a cashier but later sought to receive a promotion to customer service manager. After a series of disciplinary violations, however, Dukes was demoted back to cashier and then to greeter. Dukes concedes she violated company policy but contends that the disciplinary actions were in fact retaliation for invoking internal complaint procedures and that male employees have not been disciplined for similar infractions. Dukes also claimed 2 male greeters in the Pittsburgh store are paid more than she is. Christine Kwapnowski has worked at Sam's Club stores in Missouri and California for most of her adult life. She has held a number of positions, including a supervisory position. She claims that a male manager yelled at her frequently and screamed at female employees, but not at men. The manager in question told her to doll up, to wear some makeup, and to dress a little better. The final named plaintiff, Edith Arana, worked at a Walmart store in Duarte, California from 1995 to 2001. In 2000, she approached the store manager on more than one occasion about management training, but was brushed off. Arana concluded she was being denied opportunity for advancement because of her sex. She initiated internal complaint procedures, whereupon she was told to apply directly to the district manager if she thought her store manager was being unfair. Arana, however, decided against that and never applied for management training again. In 2001, she was fired for failure to comply with Walmart's timekeeping policy. These plaintiffs' respondents here do not allege that Walmart has any express corporate policy against the advancement of women. Rather, they claim that their local manager's discretion over pay and promotions is exercised disproportionately in favor of men, leading to an unlawful disparate impact on female employees. And respondents say because Walmart is aware of this effect, its refusal to cabin its manager's authority amounts to disparate treatment. Their complaint seeks injunctive and declaratory relief, punitive damages, and back pay. It does not ask for compensatory damages. Importantly, for our purposes, respondents claim that the discrimination to which they have been subjected is common to all Walmart female employees. The basic theory of their case is that a strong and uniform corporate culture permits bias against women to infect, perhaps subconsciously, the discretionary decision-making of each one of Walmart's thousands of managers, thereby making every woman at the company the victim of one common discriminatory practice. Respondents therefore wish to litigate the Title VII claims of all female employees at Walmart stores in a nationwide class action. Class certification is governed by Federal Rule of Civil Procedure 23. Under Rule 23A, the parties seeking certification must demonstrate first that the class is so numerous that joinder of all members is impracticable. There are questions of law or fact common to the class. The claims or defenses of the representative parties are typical of the claims or defenses of the class, and the representative parties will fairly and adequately protect the interests of the class. Second, the proposed class must satisfy at least one of the 3 requirements listed in Rule 23B. Respondents rely on Rule 23B2, which applies when the party opposing the class has acted or refused to act on grounds that apply generally to the class, so that final injunctive relief or corresponding declaratory relief is appropriate respecting the class as a whole. Invoking these provisions, respondents moved the district court to certify a plaintiff class consisting of all women employed at any Walmart domestic retail store at any time since December 26, 1998, who have been or may be subjected to Walmart's challenged pay and management track and management track promotions, policies, and practices. As evidence that there were indeed questions of law or fact common to all the women of Wal-Mart, as Rule 23A2 requires, respondents relied chiefly on three forms of proof: statistical evidence about pay and promotion disparities between men and women at the company, anecdotal reports of discrimination from about 120 of Walmart's female employees, and the testimony of a sociologist, Dr. William Bealby, who conducted a social framework analysis of Walmart's culture and personnel practices and concluded that the company was vulnerable to gender discrimination. Walmart unsuccessfully moved to strike much of this evidence. It also offered its own countervailing statistical and other proof in an effort to defeat Rule 23A's requirements of commonality, typicality, and adequate representation. Walmart further contends that respondents' monetary claims for back pay could not be certified under Rule 23B2 first, because that rule refers only to injunctive and declaratory relief, and second, because the back pay claims could not be manageably tried as a class without depriving Walmart of its right to present certain statutory defenses. With one limitation not relevant here, the district court granted respondents' motion and certified their proposed class. A divided en banc Court of Appeals substantially affirmed the district court's certification order. The majority concluded that respondents' evidence of commonality was sufficient to raise the common question whether Walmart's female employees nationwide were subjected to a single set of corporate policies, not merely a number of independent discriminatory acts, that may have worked to unlawfully discriminate against them in violation of Title VII. It also agreed with the district court that the named plaintiffs' claims were sufficiently typical of the class as a whole to satisfy Rule 23A3, and that they could serve as adequate class representatives. With respect to the Rule 23B2 question, the Ninth Circuit held that respondents' back pay claims could be certified as part of a B2 class because they did not predominate over the requests for declaratory and injunctive relief, meaning they were not superior in strength, influence, or authority to non-monetary claims. Finally, the Court of Appeals determined that the action could be manageably tried as a class action because the district court could adopt the approach the Ninth Circuit approved in Hileo v. Estates of Marcos. Their compensatory damages for some 9,541 class members were calculated by selecting 137 claims at random, referring those claims to a special master for valuation, and then extrapolating the validity and value of the untested claims from the sample set. The Court of Appeals saw no reason why a similar procedure to that used in Hileo could not be employed in this case. It would allow Walmart to present individual defenses in their randomly selected sample cases, thus revealing the approximate percentage of class members whose unequal pay or non-promotion was due to something other than gender discrimination. We granted certiorari. The class action is an exception to the usual rule that litigation is conducted by and on behalf of the individual named parties only. In order to justify a departure from that rule, a class representative must be part of the class and possess the same interest and suffer the same injury as the class members. Rule 23A ensures that the named plaintiffs are appropriate representatives of the class whose claims they wish to litigate. The rule's four requirements, numerosity, commonality, typicality, and adequate representation, effectively limit the class claims to those fairly encompassed by the named plaintiff's claims. The crux of this case is commonality, the rule requiring a plaintiff to show that there are questions of law or fact common to the class. That language is easy to misread, since any competently crafted class complaint literally raises common questions. For example, do all of us plaintiffs indeed work for Walmart? Do our managers have discretion over pay? Is that an unlawful employment practice? What remedies should we get? Reciting these questions is not sufficient to obtain class certification. Commonality requires the plaintiffs to demonstrate that the class members have suffered the same injury. This does not mean merely that they have all suffered a violation of the same provision of law. Title VII, for example, can be violated in many ways: by intentionally discrimination, or by hiring and promotion criteria that result in disparate impact, and by the use of these practices on the part of many different superiors in a single company. Quite obviously, the mere claim by employees of the same company that they have suffered a Title VII injury or even a disparate impact Title VII injury gives no cause to believe that all their claims can productively be litigated at once. Their claims must depend upon a common contention, for example, the assertion of discriminatory bias on the part of the same supervisor. That common contention, moreover, must be of such a nature that it is capable of class-wide resolution, which means that determination of its truth or falsity will resolve an issue that is central to the validity of each one of the claims in one stroke. What matters to class certification is not the raising of common questions, even in droves, but rather the capacity of a class-wide proceeding to generate common answers apt to drive the resolution of the litigation. Dissimilarities within the proposed class are what have the potential to impede the generation of common answers. Rule 23 does not set forth a mere pleading standard. A party seeking classification must affirmatively demonstrate his compliance with the rule. That is, he must be prepared to prove that there are, in fact, sufficiently numerous parties, common questions of law or fact. We recognized in Falcon that sometimes it may be necessary for the court to probe behind the pleadings before coming to rest on certification questions, and that certification is proper only if the trial court is satisfied, after a rigorous analysis, that the prerequisites of Rule 23A have been satisfied. Frequently, that rigorous analysis will entail some overlap with the merits of the plaintiff's underlying claim. That cannot be helped. The class determination generally involves considerations that are enmeshed in the factual and legal issues comprising the plaintiff's cause of action. Nor is there anything unusual about that consequence. The necessity of touching aspects of the merits in order to resolve preliminary matters, e.g. jurisdiction and venue, is a familiar feature of litigation. In this case, proof of commonality necessarily overlaps with respondents' merits contention that Wal-Mart engages in a pattern or practice of discrimination. That is so because in resolving an individual's Title VII claim, the crux of the inquiry is the reason for a particular employment decision. Here, respondents wish to sue about literally millions of employment decisions at once. Without some glue holding the alleged reasons for all those decisions together, it will be impossible to say that examination of all of the class members' claims for relief will produce a common answer to the crucial question, why was I disfavored? This court's opinion in Falcon describes how the commonality issue must be approached. There, an employee who claimed that he was deliberately denied a promotion on account of race obtained certification of a class comprising all employees wrongfully denied promotions and all applicants wrongfully denied jobs. We rejected that composite class for lack of commonality and typicality, explaining. Conceptually, there is a wide gap between an individual's claim that he has been denied a promotion or higher pay on discriminatory grounds, and his otherwise unsupported allegation that the company has a policy of discrimination, and B, the existence of a class of persons who have suffered the same injury as that individual, such that the individual's claim and the class claims will share common questions of law or fact, and that the individual's claim will be typical of the class claims. Falcon suggested two ways in which that conceptual gap might be bridged. First, if the employer used a biased testing procedure to evaluate both applicants for employment and incumbent employees, a class action on behalf of every applicant or employee who might have been prejudiced by the test clearly would satisfy the commonality and typicality requirements of Rule 23A. Second, significant proof that an employer operates under a general policy of discrimination conceivably could justify a class of both applicants and employees if the discrimination manifested itself in hiring and promotion practices in the same general fashion, such as through entirely subjective decision-making processes. We think that statement precisely describes respondents' burden in this case. The first manner of bridging the gap obviously has no application here. Wal-Mart has no testing procedure or other company-wide evaluation method that can be charged with bias. The whole point of permitting discretionary decision-making is to avoid evaluating employees under a common standard. The second manner of bridging the gap requires significant proof that Walmart operated under a general policy of discrimination. That is entirely absent here. Walmart's announced policy forbids sex discrimination, and as the district court recognized, the company imposes penalties for denials of equal employment opportunity. The only evidence of a general policy of discrimination respondents produced was the testimony of Dr. William Bealby, their sociological expert. Relying on social framework analysis, Bealby testified that Walmart has a strong corporate culture that makes it vulnerable to gender bias. He could not, however, determine with any specificity how regularly stereotypes play a meaningful role in employment decisions at Walmart. At his deposition, Dr. Bealby conceded that he could not calculate whether 0.5% or 95% of the employment decisions at Walmart might be determined by stereotypical thinking. The parties dispute whether Bealby's testimony even met the standards for the admission of expert testimony under Federal Rule of Evidence 702 and our Dalbert case. The district court concluded that Dalbert did not apply the expert testimony at the certification stage of class action proceedings. We doubt that is so, but even if properly considered, Bealby's testimony does nothing to advance respondents' case. Whether 0.5% or 95% of the employment decisions at Walmart might be determined by stereotypical thinking is the essential question on which respondents' theory of commonality depends. If Bealby admittedly has no answer to that question, we can safely disregard what he has to say. It is worlds away from significant proof that Walmart operated under a general policy of discrimination. The only corporate policy that the plaintiff's evidence convincingly establishes is Walmart's policy of allowing discretion by local supervisors over employment matters. On its face, of course, that is just the opposite of a uniform employment practice that would provide the commonality needed for a class action. It is a policy against having uniform employment practices. It is also a very common and presumptively reasonable way of doing business, one that we have said should itself raise no inference of discriminatory conduct. To be sure, we have recognized that inappropriate cases giving discretion to lower-level supervisors can be the basis of Title VII liability under a disparate impact theory, since an employer's undisciplined system of subjective decision-making can have precisely the same effects as a system pervaded by impermissible intentional discrimination. But the recognition that this type of Title VII claim can exist does not lead to the conclusion that every employee in a company using a system of discretion has such a claim in common. To the contrary, left to their own devices, most managers in any corporation, and surely most managers in a corporation that forbids sex discrimination, would select sex-neutral, performance-based criteria for hiring and promotion that produce no actionable disparity at all. Others may choose to reward various attributes that produce disparate impact, such as scores on general aptitude tests or educational achievements. And still other managers may be guilty of intentional discrimination that produces a sex-based disparity. In such a company, demonstrating the invalidity of one manager's use of discretion will do nothing to demonstrate the invalidity of another's. A party seeking to certify a nationwide class will be unable to show that all the employees' Title VII claims will in fact depend on the answers to common questions. Respondents have not identified a common mode of exercising discretion that pervades the entire company, aside from their reliance on Dr. Bealby's social framework analysis that we have rejected. In a company of Walmart's size and geographical scope, it is quite unbelievable that all managers would exercise their discretion in a common way without some common direction. Respondents attempt to make that showing by means of statistical and anecdotal evidence, but their evidence falls well short. The statistical evidence consists primarily of regression analyses performed by Dr. Richard Drogan, a statistician, and Dr. Mark Bendick, a labor economist. Drogan conducted his analysis region by region, comparing the number of women promoted into management positions with the percentage of women in the available pool of hourly workers. After considering regional and national data, Drogan concluded that there are statistically significant disparities between men and women at Walmart, and these disparities can be explained only by gender discrimination. Bendick compared workforce data from Walmart and competitive retailers and concluded that Walmart promotes a lower percentage of women than its competitors. Even if they are taken at face value, these studies are insufficient to establish that respondents' theory can be proved on a class-wide basis. In Falcon, we held that one named plaintiff's experience of discrimination was insufficient to infer that discriminatory treatment is typical of the employer's employment practices. A similar failure of inference arises here. As Judge Ikuda observed in her dissent, information about disparities at the regional and national level does not establish the existence of disparities at individual stores, let alone raise the inference that a company-wide policy of discrimination is implemented by discretionary decisions at the store and district level. A regional pay disparity, for example, may be attributable to only a small set of Wal-Mart stores and cannot by itself establish a uniform store-by-store disparity upon which the plaintiff's theory of commonality depends. There is another, more fundamental respect in which respondent's statistical proof fails, even if it established, as it does not, a pay or promotion pattern that differs from the nationwide figures or the regional figures in all of Walmart's 3,400 stores. That would still not demonstrate that commonality of issue exists. Some managers will claim that the availability of women or qualified women or interested women in their store's area does not mirror the national or regional statistics. And almost all of them will claim to have been applying some sex-neutral, performance-based criteria, whose nature and effects will differ from store to store. In the landmark case of ours, which held that giving discretion to lower-level supervisors can be the basis of Title VII liability under a disparate impact theory, the plurality opinion conditioned that holding on the corollary that merely proving that the discretionary system has produced a racial or sexual disparity is not enough. The plaintiff must begin by identifying the specific employment practice that is challenged. That is all the more necessary when a class of plaintiffs is sought to be certified. Other than the bare existence of delegated discretion, the respondents have identified no specific employment practice, much less one that ties all their 1.5 million claims together. Merely showing that Walmart's policy of discretion has produced an overall sex-based disparity does not suffice. Respondents' anecdotal evidence suffers from the same defects, and in addition is too weak to raise any inference that all the individual discretionary personnel decisions are discriminatory. In Teamsters v. United States, in addition to substantial statistical evidence of company-wide discrimination, the government, as plaintiff, produced about 40 specific accounts of racial discrimination from particular individuals. That number was significant because the company involved had only 6,472 employees, of whom 571 were minorities, and the class itself consisted of around 334 persons. Overruled on other grounds. The the 40 anecdotes thus represented roughly one account for every 8 members of the class. Moreover, the Court of Appeals noted that the anecdotes came from individuals spread throughout the company who, for the most part, worked at the company's operational centers that employed the largest number of class members. Here, by contrast, respondents filed some 120 affidavits reporting experiences of discrimination, about one for every 12,500 class members, relating to only some 235 out of Walmart's 3,400 stores. More than half of these reports are concentrated in only 6 states: Alabama, California, Florida, Missouri, Texas, and Wisconsin. Half of all states have only 1 or 2 anecdotes, and 14 states have no anecdotes about Walmart's operations at all. Even if every single one of these accounts is true, that would not demonstrate that the entire company operates under a general policy of discrimination, which is what respondents must show to certify a company-wide class. The dissent misunderstands the nature of the foregoing analysis. It criticizes our focus on the dissimilarities between the putative class members on the ground that we have blended Rule 23A2's commonality requirement with Rule 23B3's inquiry into whether common questions predominate over individual ones. That is not so. We quite agree that for purposes of Rule 23A2, even a single common question will do. We consider dissimilarities not in order to determine, as Rule 23B3 requires, whether common questions predominate, but in order to determine, as Rule 23A2 requires, whether there is even a single common question. And there is not here. Because respondents provide no convincing proof of a company-wide discriminatory pay and promotion policy, we have concluded that they have not established the existence of any common question. In sum, we agree with Judge Kaczynski that the members of the class held a multitude of jobs at different levels of Walmart's hierarchy for variable lengths of time in 3,400 stores sprinkled across 50 states with a kaleidoscope of supervisors, male and female, subject to a variety of regional policies that all differed. Some thrived while others did poorly. They have little in common but their sex and this lawsuit. We also concluded that respondents' claims for back pay were improperly certified under Federal Rule of Civil Procedure 23b2. In our opinion, in T-Court Titles Insurance Company v. Brown, expressed serious doubts about whether claims for monetary relief may be certified under that provision. We now hold that they may not, at least where, as here, the monetary relief is not incidental to the injunctive or declaratory relief. 23b2 allows class treatment when the party opposing the class has acted or refused to act on grounds that apply generally to the class, so that final injunctive relief or corresponding declaratory relief is appropriate respecting the class as a whole. One possible reading of this provision is that it applies only to requests for such injunctive or declaratory relief and does not authorize the class certification or of monetary claims at all. We need not search that broader question in this case, because we think that, at a minimum, claims for individualized relief, like back pay at issue here, do not satisfy the rule. The key to the B2 class is the indivisible nature of the injunctive or declaratory remedy warranted. The notion that the conduct is such that it can be enjoined or declared unlawful only as to all the class members or as to none of them. In other words, Rule 23b2 applies only when a single injunction or declaratory judgment would provide relief to each member of the class. It does not authorize class certification when each individual class member would be entitled to a different injunction or declaratory judgment against the defendant. Similarly, it does not authorize class certification when each class member would be entitled to an individualized award of monetary damages. That interpretation accords with the history of the rule. Because Rule 23 stems from equity practice that predates its codification, in determining its means, we have previously looked to the historical models on which the rule was based. As we observed in AmChem, civil rights cases against parties charged with unlawful class-based discrimination are prime examples of what B2 is meant to capture. In particular, the rule reflects a series of decisions involving challenges to racial segregation, conduct that was remedied by a single class-wide order. In none of the cases cited by the advisory committee as examples of B2's antecedents did the plaintiffs combine any claim for individualized relief with their class-wide injunction. Permitting the combination of individualized and class-wide relief in a B2 class is also inconsistent with the structure of Rule 23b. Classes certified under B1 and B2 share the most traditional justifications for class treatment, that individual adjudications would be impossible or unworkable, as in a B1 class, or that the relief sought must perforce affect the entire class at once, as in a B2 class. For that reason, these are also mandatory classes. The rule provides no opportunity for B1 or B2 class members to opt out, and does not even oblige the district court to afford them notice of the action. Rule 23b, by contrast, is an adventuresome innovation of the 1966 amendments. It allows class certification in a much wider set of circumstances, but with greater procedural protections. Its only prerequisites are that the question of law or fact common to class members predominate over any questions affecting only individual members, and that a class action is superior to other available methods for fairly and effectively and efficiently adjudicating the controversy. Rule 23b3, and unlike B1 and B2 classes, the B3 class is not mandatory. Class members are entitled to receive the best notice that is practicable under the circumstances, and to withdraw from the class at their option. Given that structure, we think it clear that individualized monetary claims belong in Rule 23b3. The procedural protections attending the B3 class, predominance, superiority, mandatory notice, and the right to opt out, are missing from B2, not because the rule considers them unnecessary, but because it considers them unnecessary to a B2 class. When a class seeks an indivisible injunction benefiting all its members at once, there is no reason to undertake a case-specific inquiry into whether class issues predominate or whether class action is a superior method of adjudicating the dispute. Predominance and superiority are self-evident. But with respect to each class, members' individualized claim for money. But with respect to each class member's individualized claim for money, that is not so, which is precisely why B3 requires the judge to make findings about predominance and superiority before allowing the class. Similarly, B2 does not require that class members be given notice and opt-out rights, presumably because it is thought, rightly or wrongly, that notice has no purpose when the class is mandatory, and that depriving people of their right to sue in this manner complies with the Due Process Clause. In the context of a class action predominantly for money damages, we have held that absence of notice and opt-out violates due process. While we have never held that to be so where the monetary claims do not predominate, the serious possibility that it may be so provides an additional reason not to read Rule 23b2 to include the monetary claims here. Against that conclusion, respondents argue that their claims for back pay were appropriately certified as part of a class under Rule 23b2, because those claims do not predominate over their requests for injunctive and declaratory relief. They rely upon the Advisory Committee's statement that Rule 23b2 does not extend to cases in which the appropriate final relief relates exclusively or predominantly to money damages. The negative implication, they argue, is that it does extend to cases in which the appropriate final relief relates only partially and non-predominantly to money damages. Of course, it is the rule itself, not the Advisory Committee's description of it, that governs, and a mere negative inference does not, in our view, suffice to establish a disposition that has no basis in the rule's text and that does obvious violence to the rule's structural features. The mere predominance of a proper B2 injunctive claim does nothing to justify elimination of Rule 23b3's procedural protections. It neither establishes the superiority of class adjudication or individual adjudication, nor cures the notice and opt-out problems. We fail to see why the rule should be read to nullify these protections whenever a plaintiff class at its option combines its monetary claims with a request, even a predominating request, for an injunction. Respondents' predominance test, moreover, creates perverse incentives for class representatives to place at risk potentially valid claims for monetary relief. In this case, for example, the named plaintiffs declined to include employees' claims for compensatory damages in their complaint. That strategy of including only back pay claims made it more likely that monetary relief would not predominate. But it also creates the possibility, if the predominance test were correct, that individual class members' compensatory damages claims would be precluded by litigation they had no power to hold themselves apart from. If it were determined, for example, that a particular class member is not entitled to back pay because her denial of increased pay or a promotion was not the product of discrimination, that employee might be collaterally estopped from independently seeking compensatory damages based on that same denial. That possibility underscores the need for plaintiffs with individual monetary claims to decide for themselves whether to tie their fates to the class representatives or go it alone, a choice Rule 23b2 does not ensure that they have. The predominance test would also require the district court to reevaluate the roster of class members continually. The Ninth Circuit recognized the necessity for this when it concluded that those plaintiffs no longer employed by Wal-Mart lacked standing to seek injunctive or declaratory relief against its employment practices. The Court of Appeals' response to that difficulty, however, was not to eliminate all former employees from the certified class, but to eliminate only those who had left the company's employ by the date the complaint was filed. That solution has no logical connection to the problem, since those who have left their Wal-Mart jobs since the complaint was filed have no more need for prospective relief than those who left beforehand. As a consequence, even though the validity of a B2 class depends on whether final injunctive relief or corresponding declaratory relief is appropriate, respecting the class as a whole. About half the members of the class approved by the Ninth Circuit have no claim for injunctive or declaratory relief at all. Of course, the alternative and logical solution of excising plaintiffs from the class as they leave their employment may have struck the Court of Appeals as wasteful of the district court's time, which indeed it is, since if a back pay action were properly certified for class treatment under B3, the ability to litigate a plaintiff's back pay claim as part of the class would not turn on the irrelevant question whether she is still employed at Wal-Mart. What follows from this, however, is not that some arbitrary limitation on class membership should be imposed, but that the back pay claims should not be certified under Rule 23b2 at all. Finally, respondents argue that their back pay claims are appropriate for a B2 class action because a back pay award is equitable in nature. The latter may be true, but it is irrelevant. The rule does not speak of equitable remedies generally, but of injunctions and declaratory judgments, as Title VII itself makes pellucidly clear. Back pay is neither. In Allison v. Citgo Petroleum Corp., the Fifth Circuit held that a B2 class would permit the certification. As Title VII itself makes pellucidly clear, back pay is neither. See 42 U.S.C. subsection 2000 E5 G 2BI and 2, distinguishing between declaratory and injunctive relief and the payment of back pay. In Allison v. Citgo Petroleum Group, the Fifth Circuit held that a B2 class would permit the certification of monetary relief that is incidental to requested injunctive or declaratory relief, which it defined as damages that flow directly from liability to the class as a whole on the claims forming the basis of the injunction or declaratory relief. In that court's view, such incidental damages should not require additional hearings to resolve the disparate merits of each individual's case. It should neither introduce new and substantial legal or factual issues, nor entail complex individualized determinations. We need not decide in this case whether there are any forms of incidental monetary relief that are consistent with the interpretation of Rule 23b2. We have announced and that comply with the Due Process Clause. Respondents do not argue that they can satisfy this standard, and in any event they cannot. Contrary to the Ninth Circuit's view, Wal-Mart is entitled to individualized determinations of each employee's eligibility for back pay. Title VII includes a detailed remedial scheme. If a plaintiff prevails in showing that an employer has discriminated against him in violation of the statute, the court may enjoin the respondent from engaging in such unlawful employment practice and order such affirmative action as may be appropriate, including reinstatement or hiring of employees with or without back pay or any other equitable relief as the court deems appropriate. But if the employer can show that it took an adverse employment action against an employee for any reason other than discrimination, the court cannot order the hiring, reinstatement, or promotion of an individual as an employee or the payment to him of any back pay. We have established a procedure for trying pattern or practice cases that gives effect to these statutory requirements. When the plaintiff seeks individual relief, such as reinstatement or back pay, after establishing a pattern or practice of discrimination, a district court must usually conduct additional proceedings to determine the scope of individual relief. At this phase, the burden of proof will shift to the company, but it will have the right to raise any individual affirmative defenses it may have, and to demonstrate that the individual applicant was denied an employment opportunity for lawful reasons. The Court of Appeals believed that it was possible to replace such proceedings with trial by formula. A sample set of the class members would be selected as to whom liability for sex discrimination and the back pay owing as a result would be determined in depositions supervised by a master. The percentage of claims determined to be valid would then be applied to the entire remaining class, and the number of presumptively valid claims thus derived would be multiplied by the average back pay award in the sample set to arrive at the entire class recovery, without further individualized proceedings. We disapprove that novel project. Because the Rules Enabling Act forbids interpreting Rule 23 to abridge, enlarge, or modify any substantive right, a class cannot be certified on the premise that Wal-Mart will not be entitled to litigate its statutory defenses to individual claims. And because the necessity of that litigation will prevent back pay from being incidental to the class-wide injunction, respondent's class could not be certified, even assuming arguendo that incidental monetary relief can be awarded to a 23B2 class. The judgment of the Court of Appeals is reversed. Justice Ginsburg, with whom Justice Breyer, Justice Sotomayor, Justice Kagan joined, concurring in part and dissenting in part. The class in this case, I agree with the court, should not have been certified under Federal Rule of Civil Procedure 23B2. The plaintiffs alleging discrimination in violation of Title VII, 42 U.S.C. subsection 2000E, seek monetary relief that is not merely incidental to any injunctive or declaratory relief that might be available. A putative class of this type may be certifiable under Rule 23B3 if the plaintiffs show that common class questions predominate over issues affecting individuals. For example, qualification for and the amount of back pay or compensatory damages, and that a class action is superior to other modes of adjudication. Whether the class the plaintiff describes meets the specific requirements of Rule 23B3 is not before the court, and I would reverse that matter for consideration and decision on remand. The court, however, disqualifies the class at the starting gate, holding that the plaintiff cannot cross the commonality line set by Rule 23A2. In so ruling, the court imports into the Rule 23A determination concerns properly addressed in a Rule 23B3 assessment. Rule 23A2 establishes a preliminary requirement for maintaining a class action. There are questions of law or fact common to the class. The rule does not require that all questions of law or fact raised in the litigation be common. Indeed, even a single question of law or fact common to the members of the class will satisfy the commonality requirement. A question is ordinarily understood to be a subject or point open to controversy. Thus, a question common to the class must be a dispute either of fact or of law, the resolution of which will advance the determination of the class members' claims. The district court, recognizing that one significant issue common to the class may be sufficient to warrant certification, found that the plaintiffs easily met that test. Absent an error of law or an abuse of discretion, an appellate tribunal has no warrant to upset the district court's finding of commonality. The district court certified a class of all women employed at any Wal-Mart domestic retail store at any time since December 26, 1998. The named plaintiffs, led by Betty Dukes, proposed to litigate on behalf of the class allegations that Wal-Mart discriminates on the basis of gender in pay and promotions. They allege that the company relies on gender stereotypes in making employment decisions such as promotions and pay. Wal-Mart permits those prejudices to infect personnel decisions, the plaintiffs contend, by leaving pay and promotions in the hands of a nearly all-male managerial workforce, using arbitrary and subjective criteria. Further alleged barriers to the advancement of female employees include the company's requirement as a condition of promotion to management jobs that employees be willing to relocate. Absent instruction otherwise, there is a risk that managers will act on the familiar assumption that women, because of their services to husband and children, are less mobile than men. Women fill 70% of the hourly jobs in the retailer stores, but make up only 33% of management employees. The higher one looks in the organization, the lower the percentage of women. The plaintiff's largely uncontested descriptive statistics also show that women working in the company's stores are paid less than men in every region, and that the salary gaps widen over time even for men and women hired into the same jobs at the same time. The district court identified systems for promoting in-store employees that were sufficiently similar across regions and stores to conclude that the manner in which these systems affect the class raises issues that are common to all class members. The selection of employees for promotion to in-store management is fairly characterized as a tap-on-the-shoulder process in which managers have discretion about whose shoulders should tap. Vacancies are not regularly posted. From among those employees satisfying minimum qualifications, managers choose whom to promote on the basis of their own subjective impressions. Walmart's compensation policies also operate uniformly across stores, the district court found. The retailer leaves open a $2 band for every position's hourly pay rate. Walmart provides no standards or criteria for setting wages within that band and thus does nothing to counter unconscious bias on the part of supervisors. Walmart's supervisors do not make their discretionary decisions in a vacuum. The district court reviewed means Walmart used to maintain a carefully constructed corporate culture, such as frequent meetings to reinforce the common way of thinking, regular transfers of managers between stores to ensure uniformity throughout the company, monitoring of stores on a close and constant basis, and Walmart TV broadcast into all stores. The plaintiff's evidence including class members' tales of their own experiences, suggests that gender bias suffuses Walmart's company culture. Among illustrations, senior management often refer to female associates as little Jane Qs. One manager told an employee that men are here to make a career and women aren't. A committee of female Walmart executives concluded that stereotypes limit the opportunities offered to women. Finally, the plaintiffs presented an expert's appraisal to show that the pay and promotions disparities at Walmart can be explained only by gender discrimination and not by neutral variables. Using regression analyses, their expert Richard Dragan controlled for factors including inter alia, job performance, length of time with the company, and the store where an employee worked. The results, the district court found, were sufficient to raise an inference of discrimination. The district court's identification of a common question, whether Walmart's pay and promotions policies gave rise to unlawful discrimination, was hardly infirm. The practice of delegating to supervisors large discretion to make personnel decisions, uncontrolled by formal standards, has long been known to have the potential to produce disparate effects. Managers, like all humankind, may be prey to biases of which they are unaware. The risk of discrimination is heightened when those managers are predominantly of one sex and are steeped in a corporate culture that perpetuates gender stereotypes. The plaintiff's allegations resemble those in one of the prototypical cases in this area, Lesnar v. New York Telephone Company. In deciding on promotions, supervisors in that case were to start with objective measures, but ultimately they were to look at the individual as a total individual. The final question they were to ask and answer, is this person going to be successful in our business? It is hardly surprising that for many managers, the ideal candidate was someone with characteristics similar to their own. We have held that discretionary employment practices can give rise to Title VII claims not only when such practices are motivated by discriminatory intent, but also when they produce discriminatory results. In Watson, as here, an employer had given its managers large authority over promotions. An employee sued the bank under Title VII, alleging that the discretionary promotion system caused a discriminatory effect based on race. 4 different supervisors had declined on separate occasions to promote the employee. Their reasons were subjective and unknown. The employer, we noted, had not developed precise and formal criteria for evaluating candidates. It relies instead on the subjective judgment of supervisors. Aware of the problem of subconscious stereotypes and prejudices, we held that the employer's undisciplined system of subjective decision-making was an employment practice that may be analyzed under the disparate impact approach. The plaintiff's allegations state claims of gender discrimination in the form of biased decision-making in both pay and promotions. The evidence reviewed by the district court adequately demonstrated that resolving those claims would necessitate examination of particular policies and practices alleged to affect adversely and globally women employed at Walmart stores. Rule 23A2, setting a necessary but not sufficient criterion for class action certification, demands nothing further. The court gives no credence to the key dispute common to the class, whether Walmart's discretionary pay and promotion policies are discriminatory. What matters, the court asserts, is not the raising of common questions, but whether there are dissimilarities within the proposed within the proposed class that have the potential to impede the generation of common answers. The court blends Rule 23A2's threshold criterion with the more demanding criteria of Rule 23B3, and thereby elevates the A2 inquiry so that it is no longer easily satisfied. Rule 23B3 certification requires, in addition to the 423A findings, determinations that questions of law or fact common to class members predominate over any questions affecting only individual members, and that a class action is superior to other available methods for adjudicating the controversy. The court's emphasis on differences between class members mimics the Rule 23B3's inquiry into whether common questions predominate over individual issues, and by asking whether the individual differences impede common adjudication, the court duplicates 23B3's question whether class action is superior to other modes of adjudication. Indeed, Professor Nagareta, whose dissimilarities inquiry the court endorses, developed his position in the context of Rule 23B3. If the court must conduct a dissimilarities analysis at the Rule 23A2 stage, no mission remains for Rule 23B3. Because Rule 23A is also a prerequisite for Rule 23B1 and 23B2 classes, the court's dissimilarities position is far-reaching. Individual differences should not bar a Rule 23B1 or Rule 23B3 or 23B2 class, so long as the Rule 23A threshold is met. For example, in Franks v. Bowman Transport Company, a Rule 23B2 class of African American truck drivers complained that the defendant had discriminatorily refused to hire black applicants. We recognize that the qualifications and performance of individual class members might vary. The dissimilarities approach leads the court to train its attention on what distinguishes individual class members rather than on what unites them. Given the lack of standards for pay and promotion, the majority says, demonstrating the invalidity of one manager's use of discretion will do nothing to demonstrate the invalidity of another's. Walmart's delegation of discretion over pay and promotions is a policy uniform throughout all stores. The very nature of discretion is that people will exercise it in various ways. A system of delegated discretion, Watson held, is a practice actionable under Title VII when it produces discriminatory outcomes. A finding that Wal-Mart's pay and promotions practices in fact violate the law would be the first step in the usual order of proof for plaintiffs seeking individual remedies for company-wide discrimination. That each individual employee's unique circumstances will ultimately determine whether she is entitled to back pay or damages. The court errs in importing a dissimilarities notion suited to Rule 23B3 into the Rule 23A commonality inquiry. I therefore cannot join Part 2 of the court's opinion. Well, that was a good read. As always, if there's any case you'd like me to read, just drop it in the comments and I'd be happy to take a look. Thank you.